and Article 226. Both these articles of the Constitution give you a right to file a case which you say is affecting public interest. I filed on this EVMs, that EVMs without a voter slip, which is now called VVPAT, voter verifiable, some VVPAT is the way. Voter verifiable, I remember. This is the first two VVs. That is, your screen is there. When you press the button, you can see which is the candidate who has been selected. And then a slip comes down. That you can't touch, but you can see. That tells you whom you have voted for. It drops into a box. And the box is sealed. And if there is a dispute, the box is counted and not rerun of the same machine. Because just now, without the VVPAT, the machine, if there is a dispute, election dispute, then the same electronic voting machine is rerun. You're asking the same machine whether you have made a mistake or not, it will never do. So to correct for that, I brought this in. And what did I do? I filed a petition in the Supreme Court under 32, Article 32, saying my fundamental rights have been infringed because there is doubt, and I proved to them that how it can be rigged. You know that the electronic voting machine, the brain of the electronic voting machine is a chip. Is the chip produced in India? No. It is produced in Japan. And in Japan, it is produced by a private limited company. Now, Bharat Electronics doesn't produce it, nor the Electronic Corporation of India produce it. A private company in Japan produces it. So you can imagine how vulnerable it is. There is no safeguards for it. And they can program the chip in such a way that you can sit in a distance from with a mobile phone and you can feed in the data which will correct what the data exists. Or it will put into that you will get one vote and your remaining 9 votes for every 10 votes will go to other people. So the electronic voting machine can be rigged. And so I asked the Japanese, in your Japanese election, don't you feel frightened that this kind of thing, in the hands of a private company will rig your electronic voting machine? He said, what electronic machine? We don't use electronic machines in Japan. We use ballot papers. Germany, Supreme Court ruled there. No electronic voting machine. And they said ballot papers. So since the last 10 years, Germany has been using ballot papers. England uses ballot papers. United States largely uses ballot papers, except occasionally supporting systems they have electronic. There is no democratic country I know which uses electronic voting machines. Nigeria uses electronic voting machines. They bought it from India. So when I was arguing the case, the Election Commission said, there's big demand from foreign countries for our machine, and our own people are demeaning it. So I asked the court, please ask them which countries. So he says, Nigeria and Venezuela. Venezuela is a dictatorship. Nigeria is a dictatorship. And they also said that Malaysia is showing some interest in it. Well, these are countries that are not democratic. But I will still say that electronic voting machine with VVPAT, the probability of it being genuine will be more than 95%. No electronic machines are unriggable. Everything is hackable. But some are more difficult, some are more easy. Electronic voting machines with VVPAT means that you are probably secure in the election results. Now the Congress party is making a big hullabaloo about it. They're even quoting my judgment, which has appeared in 2014 Supreme Court cases. But at that time they were virulently opposing me, saying that they're looking for excuses for having lost the election, etc. But today they recognize that. But so this is something that I did just by filing under Article 32 of the Constitution. In Delhi, you can file under 226. And Delhi, 226 is much wider. I filed the Sunanda murder case in Article 226 and said that she dies in 17th January 2014 and no FIR for the whole year. Finally, I wrote a stiff letter to Rajnath. Rajnath fired the police and they fired it after 1 year of her death. They filed an FIR. The autopsy report or the postmortem report, that says that she died of unnatural causes due to poisoning. Now, the husband should be in my support, but the husband is attacking me, saying that why is this man raking up this? She died of natural causes. How does he know? So, therefore, there was something she had threatened to expose the IPL fraud in which she was a party. And they were all scared that all their names will come out. IPL is the biggest fraud controlled by Dawood Ibrahim, I'm telling you. And the amount of money that is laundered through that is unbelievable. We have to clean it up. Supreme Court has done quite a lot of good work by restructuring BCCI, but the money is so much that even good officers, even if you appoint them, they can find temptation very difficult. So that, you see, finally it went before Justice Shishtani in Delhi High Court. He saw the merit in what I said. He asked the police, give us a timeline by which you will decide. 6 hearings went where I had convinced the court that the police had been deliberately delaying the hearing. All of a sudden on the 7th hearing, when the Delhi police was to go to provide the answer on which date they will close it, we get a new judge. Now, I know this new judge because when I was law minister in 1990-91, I had appointed a very good man as Attorney General called G. Ramaswamy. He was his junior. And my first recollection of him is that he came to serve me tea, as the juniors are prone to do for lawyers, I think. You can ask the lawyers here what they make their juniors do. But the fact is that he was in that. There were other factors which he was left wing, I was right wing. There was I was a Sanghi, as they call me. So there was that tension. Now suddenly he parachutes into this case, and instead of taking up the police affidavit and the status report, he starts by saying, you have made lots of accusations. Why didn't you say in your petition that you are BJP? I say, is there anybody in the country who doesn't know I'm from BJP? He says, I don't know. I said, well, you should have. I've said I'm a member of parliament, so I must be a member of some party. And I've said that I was cabinet minister of such and such government. So, but he said, no, I think you have prejudiced, you are making political capital out of this. I'm dismissing the case. I have never seen such rocket speed dismissal of a case. Well, I have a motto, give as good as you get. So the judge will hear from me soon in a formatted way in which he will understand. But that was clearly a motivated judgment, in the sense it was a lack of application of mind. So you have that problem. But I will say, by and large, our judiciary is... time factor? No. By and large, the judiciary is good, better than most countries of the world. And almost as independent as the American court system. So people run down our court system. Do you know that how much our judges work? Supreme Court, United States, considers only 200 cases a year. In our Supreme Court, they consider 200 cases per day. What a load. Supreme Court in the United States says the person who is a petitioner, he will be given 20 minutes to state his case. The respondent will be given 20 minutes to state his case. And the petitioner again will be given 10 minutes to rebut that case. In our country, every lawyer, especially the senior lawyers, they argue for days because they get paid by days. So they are daily wage basis. So go on arguing, hours and hours. Once, when I was law minister, I decided that there should be some limit. So I said, why not make discovery and interrogatories compulsory? So that all this document producing, verifying this thing, can be all done before reaching the court. So the Chief Justice called me up and said, I hear you are planning to bring out an amendment to the CPC to make this compulsory. That no matter will go to trial unless this is compulsorily done, first done. He says, please don't do it. I said, why? It is there already in the CPC. A provision is there that you can do it. That is, you can use interrogatories and discovery. But I'm making it compulsory. What is wrong? He said, all the lawyers will go on strike. So I said, why? He says they will have to do their homework, which they don't want to do. Most of them believe in arguing the matter, and in the process of argument thinking of news. So therefore don't do it. So I could not do it, because lawyers also told me that no, this is not suitable for India. You're getting all these American ideas, please give it up. So I could not do it when I was law minister. But I think that this is something that we must do. Now in the case of Mr. Chidambaram, who is supposed to be a lawyer, and I must tell you, he reminded me in 1977, and he must be regretting that he reminded me, that he was my student while I was teaching at Harvard. So I didn't remember him. So I went back to my, grade sheets, where I've maintained marks over the years that I had been professor. And I found that he was a student from the business school, taking one of my compulsory courses and getting a C. That means fail. So, naturally, he's not well disposed to me. But the fact of the matter is that I'll give one case, Aircel Maxis. What is Aircel Maxis case on which his son has been raided and all that? Now Chidambaram is also going to be brought into the net. There was an Indian company called Aircel in Madras, and its shares were 100% owned by the owner. Now, a Malaysian company called Maxis, owned by one Anantakrishnan, formerly of Sri Lanka, and settled there. Maybe he's LTT also, I don't know. But he wanted to buy an Indian company by buying the shares of that company. Indian law under foreign direct investment says no foreigner can buy more than 74% of the share capital of any Indian company, and the rest 26% must be owned by an Indian. So this gentleman, what he does, this Maxis gentleman, this Anantakrishnan, he creates an Indian company with a lady as chairman who has nothing to do with telecom, and then finances the 26% purchase with a proviso in the agreement with that company that whenever the financier, which is one of his companies, wants to re-own the shares, he is entitled to do so. So this 26% company, called some Scindia Securities or something, comes in as the Indian partner. The deal is cleared by Mr. Chidambaram. He approves it as finance minister, the Foreign Investment Promotion Board. Now, first of all, Mr. Chidambaram in his defense says, I cleared it because all the bureaucrats signed it and sent it to me, that is for clearance. Yes, the bureaucrats say they have met all the conditions, but the approval means you have to yourself see that everything is done according to law. And that is a Supreme Court judgment called Shamsher Singh versus the Union of India, which is a constitutional bench judgment, which says that the Constitution and the law recognizes only the minister. The bureaucrats may be given it may be decentralized, delegated, anything, but that has no value at all. The responsibility for approval given for such things as FIPB or approval by the minister for anything, the minister is responsible solely. That's a constitutional bench judgment. So therefore he gave this clearance. So he should have investigated that what is this India Securities, where it is money coming from. It would have been now there obvious itself that it's a Benami company of Mr. Anantakrishnan. He didn't do that. Second, if the foreign direct investment is more than 600 crores at that time, 2006, then it has to necessarily go to the Cabinet Committee on Economic Affairs. Of course, Mr. Chidambaram as Finance Minister is also a member of that. But he didn't send it. He cleared it. He should have known that it is over 600, it was 4,000 crores. So it was more than 600 crores. So he should have sent it to the Cabinet Committee on that. And Cabinet Committee compulsorily would then refer it to the Home Ministry for security clearance. And security clearance would have shown that 27% of the shares of Maxis is owned by Saudi Telecom, which has a partnership with Pakistan Telecom. So they would not have given security clearance. And knowing this, Chidambaram himself cleared it. So he is caught on the third thing is the Prevention of Corruption Act says that if the minister is caught taking bribe, etc., 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 but 13(1)(d) part 3 of the Prevention of Corruption Act says that even if the minister does not take a bribe, but he enables somebody else to get pecuniary benefits, then also the minister can be prosecuted. He is culpable in the crime. Karti Chidambaram had beautifully benefited. He had 21 bank accounts abroad. He had a mansion jointly owned with his father in Cambridge University campus, not campus, but the Cambridge town. I mean, it's a total disproportionate to his known sources of income. And Karti is now been raided, everything has been documented. Now the matter comes up to Mr. Chidambaram that he who approved it, and so therefore you have to be prosecuted. His father and son both better pack up their bags because it's an open shut case. And wife is not going to be left behind, which is that is not fair. She is caught up in the Sharda chit fund. She was a lawyer for one party and she took money from the other party to advise him how to lose the case. I don't know what she did, but she's being prosecuted by CBI in that also. So there will be a family reunion. Here Vadra and Rahul and Sonia, another family. All the families are, we are not being cruel in this. We are taking care that the families are not divided in this matter. Now, last question I will say. I had one wanted to do, I think 2 minutes I'll do. This defamation case, I took it to the Supreme Court, and where I failed. I nearly succeeded, but my government was dead against my winning it, that they put up a real battery of lawyers to oppose me. And that was this. Should you be sent to jail for something you said, which may be defamatory? I think all over the world now the trend is that you can be sued, you can be made culpable for damages, but you should not be sent to prison. Because prison is a traumatic experience, especially for well-to-do people. You say something, somebody distorts it and publishes it, and then there's a defamation case, then you have to go to court, and it's a criminal court. So the criminalization of defamation, I said, should be declared as unconstitutional, That is the international practice. That is the United Nations resolutions also. And it's a world over, democratic countries are getting rid of it. And they are only keeping suit for damages. And suit for damages, the Americans, and on one of my earlier cases in 1994, the Supreme Court of India said that if a public person, a public figure files for defamation for damages, then the onus will shift on him to prove that what was said about him was not only not true, but the maker of that defamation knew it was not true and yet he made it. That is called reckless disregard of the truth. That's the American law. So no public figure there can ever succeed in a defamation case. Why? Because who will be able to prove that? And why are this thing done for the public figures? Because the Supreme Court of America says that a public figure can hold a press conference and say, this is all rubbish, I challenge him to prove it. Or have some, let's have a joint press conference and see who gets the better of the, convinces the press more or the public more. So the public person has a right to go to the media, and he has access to the media to make, and therefore he should be subject to a stricter standard than an ordinary person, an ordinary shopkeeper, an ordinary salesman who is defamed, who loses his entire business, but he is not in a position unless he is given the right for criminal defamation. So therefore, criminal defamation is there, it should be only restricted to non-public persons, but unfortunately the Supreme Court accepted all my arguments, but somehow in the last paragraph they said, however, we think that criminal defamation should continue as a salutary measure, etc. But I'll again rake it up somewhere else and bring it in and again argue the matter when the new bench is constituted, when new Chief Justice comes. Mr. Gogoi is the next. So because the man who rejected my petition is presently Chief Justice, so I'll have to wait till he retires and goes. But he's a very good judge, must I say. I have a very high regard for him. He's listening to me on the Ram temple matter.
Which I would like to hear, sir.
Now, what is this Ram temple all about? In short, are we going to win this case? 120% certain. I won the Ram Setu case when nobody thought I could win it. The Chief Justice, Mr. Balakrishnan, said to an earlier set of people, they were Dharmacharyas, Shankaracharyas and people of various mutts, every one of them were brought together by Sudarshan ji of RSS and Vishwabandhu Parishad's Ashok Singhal. And they had gone in the Ram Setu issue, saying that the Setu Samudram project proposed by the UPA government will to cut through, a canal to cut through the Ram Setu. See, if you look at the map of India, the southern coast is like that, Sri Lanka is like that, and an island juts out which is called Rameshwaram Island. Old days it used to be called Pamban Island, now we call it Rameshwaram Island. It ends in a place called Dhanushkodi, where you remember Ramchandraji took out his Agni Band. So Dhanushkodi it ends, and from there Ram Setu starts. And it goes up to Sri Lanka coast. And there you can, if you walk on it, you can reach Sri Lanka by walking. So, therefore, Rameshwaram Island plus Ram Setu, these two block any ship from going through the Gulf of Mannar and the Pak Strait. So, every ship which comes to Kanyakumari or to Tuticorin has to go around Sri Lanka to go to Chennai or to Visakhapatnam or even to Calcutta. So, therefore, it is more time consuming, more expensive. So in the interest of development, you cut because it's a shallow base, the bed of the ocean is shallow. So therefore it's only not enough to clear big ships. So they decided to cut a canal on the ground of that Park Strait and Gulf of Mannar, and cut through Ram Setu so that ships can go through. This was their plan. Of course, privately, Karunanidhi said that to Muslims that they demolished Babri Masjid, so I will demolish Ram Setu for you. And so kindly vote for me. That's the kind of propaganda he was doing. And of course, Sonia Gandhi, as a good Christian, she was also enjoying this, fully supporting him on that, in public meetings and all that. So now, I don't know what the people, all these sadhu sannyasis got agitated, so they came together, signed a big petition, they filed the petition, Supreme Court dismissed it. That is reckless. Development cannot suffer like this on an imaginary idea of Ram Setu. So Supreme Court was very hostile. So then I was approached. I said, well, they have already got a case dismissed. I can't go again. There's find some way, because most people don't know the law, so they think there's always some way. So I said, okay, if Ramchandraji wants me to save Ram Setu, he'll put some idea into my brain. So I started thinking. Then I found the way. The way was that I went to court and I raised the same objections as the sadhu sannyasis raised. Namely, that this will break Ram Setu, etc., it will hurt our faith and all that. But I added one paragraph, that if the purpose of the Setu Samudram project was to enable ships to go through, or the luggage or the cargo to go through in a shorter distance, then we have to consider the 3,600 crore project vis-a-vis an alternative way of sending this luggage or this cargo to Chennai and Visakhapatnam in Calcutta. And I produced, thanks to a friend, and I would say Ramchandraji, that there was a study by the Planning Commission that if the ships which come the Tuticorin port could be converted into a container port, then they can drop that cargo in Tuticorin, and a railway line can be built along the coast and up to Calcutta, and that cost will be only 600 crores. So I went to court, and the court was very angry with me. So why have you come? Don't you know that they have dismissed it? I said, they have dismissed it on religious grounds. I am not on religious grounds. I am worried about my the country's exchequer, the consolidated accounts of India. And on the consolidated fund, you can't withdraw money like this. 3,600 crores for what can be achieved with 600 crores. Therefore, the alternative is cheaper, and you have to consider it. Therefore, this is arbitrary, this is unreasonable, and this is therefore, defrauding the public exchequer, etc. The court got convinced. It said, all right, we will hear your matter. And then the process started of hearing the matter. I convinced the court that if you really want to move cargo faster, instead of going around Sri Lanka, then put through the railway line. So now the government of the UPA resisted it tooth and nail. They went on raising all kinds of questions. One question they persuaded the judge to ask me. He said, Mr. Swamy, tell me, do you really mean to say that people will go to the middle of the ocean to worship Ram Setu? So I said, Your Lordship, every morning I worship to Lord Surya Bhagwan, and I don't go to Surya and come back. And the judge's name was Ravindran. I said, your name is Ravindran, you should at least know this. So, like that, you see, once I said, this is Ram Setu, so Karunanidhi got very upset. He said, who is he to say it's Ram Setu? Was Rama an engineer? Which engineering college did he go to? How do I answer that? But Ramchandraji answered. Next day he fell sick. So he had to be admitted to hospital. Hospital's name was Ramchandra Medical Hospital. So I sent a message to Karunanidhi, get well soon, but are you sure he's got an MBBS at least? So this is the kind of, this is a skill which you have to acquire by experience. You can't, there's no book which will teach you this. That I came up, anything, any policy, normally Supreme Court will not accept any policies. But if the policy is arbitrary, if it is unreasonable, if it is illegal, then the Supreme Court will intervene. And that is what I am doing in many of these cases. The Jet Etihad case which is coming up, the 2G spectrum, what did I do? I said if they had auctioned the spectrum, they would have got 10 times the revenue they got by the method they adopted, and therefore cancel it. And the court cancelled it. And today the government is getting more revenue from auctioning than income tax. So I'm saying abolish income tax. Now I've given you another method of raising resources. Same thing we did with coal. That also going for auction. 11 lakh crores you will get in that. So the law has now become an instrument by which the government can be kept in check. And therefore it's a great profession. I would advise everybody to learn it because you become strong. If a policeman comes to your house, you know how to deal with him. Today people get frightened. Oh, a policeman aa gaya, you see. I have all these securities, all these CRPs, and when I end up going to somebody's house, they think that I'm raiding their house, you see. Poor chaps have to give an explanation. So the fear of the law is not a good thing. Respect for the law, yes, but you should love the law, and the law can be used in your favor. And of course I'll put all the lawyers out of business by making you do that. There's a story that in hell there was a football match going on. So somebody kicked the ball very hard. So it hit the wall dividing heaven and hell, and the wall collapsed. So the heaven people came and said, hey, you've broken the law, I've broken the wall, kindly rebuild it. They said, why we should rebuild it? You're afraid of our coming there. We are not afraid of your coming here. So you build it. So they said, oh, you don't agree, okay, we'll go to Brahma's court and have this settled. So both started searching for the best lawyers, and on the day of the hearing, the hell people came with large number of top lawyers, but the heaven people couldn't find a single lawyer. So you know where the lawyers end up. Even if you are a doctor, even if you are an engineer, even if you are a housewife, there is a way to learn law online. It's not difficult. And you need to know basic concepts, what your rights are. When you can be arrested, when you can't be arrested, when you can be, the police can come to your house, when you can be called to the police station, when you cannot be called. All these things are simple things. These are social rules. And the law is the way. It's no use saying the law is corrupt, judges are corrupt. This cynicism is not going to improve society. I myself entered politics in 1970, and today I will say we are a much more democratic society today than we were in 1970. And we have to continue this because we have come after 1,000 years of foreign invasions and so on. And consequently, you now need to have an approach that this society has to be restructured, and for that we have to keep fighting. Keep fighting without worrying whether you're going to win or lose. And there you'll create a chemistry by which you will see that ultimately every one of you individually becomes strong, then the country becomes strong, and then only the country becomes strong. Thank you very much.